All right. Mr. Hill, you've got Senate Bill 1017 before us.
Thank you, Mr. Chair. Let me first accept the committee amendments listed in the analysis. SB 1017 is one element of the PUC reform package that you, Mr. Chair, and the Governor, Senator Leno, and I endorsed on earlier this week, that we all signed on to. The Governor has been adamant about reshaping the confidentiality provisions of Public Utilities Code since vetoing 3 PUC reform bills last year by yourself and the Speaker and myself. In his veto message, he called out Section 583 in particular as a barrier to timely access to public documents. This bill, as amended, would do 3 things. First, it would clarify what is already true, that the PUC can develop a regulation to determine how to manage Public Records Act requests, and that a commission vote is not required to answer every request. Second, would also clarify that it is a misdemeanor for PUC staff to release documents for gain or to disrupt a competitive industry, but not, if required, as a part of a whistleblower complaint to the state auditor or as part of an interagency MOU. Utilities have had data breaches as well, many times involving customer information, but no one at the utility goes to jail unless it's malicious. It is inappropriate to say that scaring PUC employees with jail time for responding to a Public Records Act request is in any way appropriate. And third, it requires the PUC to develop procedures to expeditiously release information regarding health and safety emergencies, public employee or contractor safety, and failures that damage the environment, such as Aliso Canyon and the Butte Fire. I have a number of examples of why this is needed, and I can share them, but first I'd like to go straight to the heart of this issue. Let me be clear. This bill does not take away due process. This bill does not allow the PUC to take away due process at all. Due process is guaranteed by the state and federal constitutions. Nothing we can do will change that. Some of the opposition appears to be confused on that fact. This bill also does not put customer information at jeopardy. Customer information is already protected in a series of state and federal laws, and I can enumerate some of them if you'd like. Nothing in this bill changes existing confidentiality laws. In fact, all this bill does is allow the Public Utilities Commission greater discretion in determining its own processes for releasing information. It does not change what information the PUC may release, and it doesn't change the types of information that a utility can label as confidential. The danger in this bill is that it doesn't go far enough, as we've discovered that the PUC, when left to its own devices, is too deferential to utility wishes. I'm fully committed to working with the utilities, as well as the wide coalition of public interest groups, utility unions, public employee unions, and environmental groups in support of this bill to most effectively address the Governor's concerns. But to do nothing is no longer an option. Thank you, members, for the indulgence.
Thank you very much. Witnesses in support.
Mr. Chair, members, Jim Ewert with the California Newspaper Publishers Association. I want to thank you, Senator Hill and Senator Leno, for all of the work you've done in this area. And we're in support of the measure, and with the committee's amendments, we think it's a good step forward. It furthers the purpose of the Public Records Act in providing records to the public promptly without undue delay. And we also look forward to Mr. Patterson's point, to the point where the amendments come through that deal with the jurisdictional problems posed, an obstacle posed by current PUC Code Section 1759, dealing with the ability of a requester to file an action in a superior court. And for these reasons, we urge an aye vote.
Thank you very much. Next witness.
Barry Broad for the Utility Workers Union and Engineers and Scientists of California in support of the bill. I think the bill is really trying to conform the way PRA requests are done pretty much by the rest of the state, and local governments in California. It's sort of an unusual process at the PUC.
Terrific. Public comment and support.
Eddie Moreno on behalf of Sierra Club California in support.
Morgan Carvajal with the Hernandez Strategy Group on behalf of the Utility Reform Network, also in support.
Thank you. Let's go to witnesses in opposition.
one more support.
Sure, go ahead.
Pat Whalen, Ellison Wilson Advocacy here on behalf of CASE, that's California Attorneys, Administrative Law Judges, and Hearing Officers in State Employment. We have about 100 or so attorneys and judges at the PUC.
Terrific. I see a lot of folks coming up to testify in opposition. Please keep it short and kind of have the honorable thing of limiting your remarks to about what the proponent said, so that, or time-wise. Thank you.
Pam Loomis on behalf of Consolidated Communications in opposition to SB 1017. The proponents are arguing that Public Utilities Code 583 is hindering the Public Records Act requests that are coming to the Commission, but we'd like to point out that these statutes deal with very different information. The Public Records Act is about getting access to government records, not confidential corporate records. And Section 583 is about providing protections to utility and corporate information, and for a very good reason. Just a couple of sections away from 583 is Section 581, which gives the Commission staff, which includes ORA staff, authority to ask for any information at any time and for any reason. And we have to comply with these data requests. So the protections of 583, which are having notice and an opportunity to respond to the Commission's consideration of releasing our confidential information, which is what we refer to as due process, is extremely important in light of the vast authority that the Commission has to ask for anything and everything from the utilities, and that the Commission holds, and that could be subject to a Public Records Act request. Frankly, 583 doesn't need to be modified to make the Commission more efficient in responding to Public Records Act requests. 583 allows for the appropriate release of utility information upon Commission vote or in a Commission proceeding, again, which provide us with notice and an opportunity to respond. Really, SB 1017 is intended to create a staff process where the information can be released without notice or an opportunity to object. And this is fortified by a proposed decision released by President Picker yesterday that directs the legal division staff to review the confidentiality of utility information and determine whether that's going to be released. And there is no notice to the utility whose information is the subject of the request or an opportunity to respond.
I need you to wrap it up, please. Thank you.
In conclusion, the communications industry is a highly competitive and diverse industry. Consolidated Communications would not want its information released, especially if it hasn't had a notice and an opportunity to be heard. We think that there is a solution that could provide us notice and opportunity to be heard and still allow for the timely response to Public Records Act requests. And we need to oppose this bill until we are provided those due process rights. Thank you.
Thank you. Next witness.
Good afternoon. Rudy Reyes with Verizon. We actually agree with the recent announcement and broader goal of PUC reform that was announced by the governor, the chair, and the senator. But we must respectfully oppose this specific measure in its current form. The irony for us, Verizon as a wireless company, is that we wouldn't even be in this bill but for the ongoing regulatory overreach into wireless and IP by the PUC. This overreach is real. The PUC uses its legacy authority embedded in the PU code over monopoly public utilities as a wedge to try to expand its authority into wireless and IP and ask us all sorts of detailed questions about our confidential business operations, which, if disclosed, would not only harm the company, but it would potentially harm the functioning of competitive markets and therefore consumers. This isn't hypothetical. The industry recently had to go to federal court to enjoin the PUC from unlawfully disclosing our highly confidential information to outside parties. We got a preliminary injunction against the PUC. At the state level, Section 583 is our only protection against improper and unauthorized disclosure of our most sensitive information. Unless this bill is amended to address the critical need to protect competitively sensitive confidential information from improper disclosure, we must respectfully oppose the bill. Thank you.
Members of the committee, Bill Devine with AT&T. We do share the concern over Section 583, and what is frequently overlooked with regard to Public Record Act release of information are the points that Pam Loomis just made, and that is there are provisions in the PU Code, specifically 584, for example, that requires us to turn over to the Commission any and all information that they ask for. And I might add, they have the right to ask for information on the unregulated businesses of AT&T. Those unregulated businesses represent well over 90 to 95% of our actual revenue, and they're allowed to gain access to that information. It would be extremely detrimental if that information was released at the staff level, or if, as a result of removing the misdemeanor, that information was released through leaks. However, we are working closely with the author. I think he has a deep appreciation for our concerns. We're also working with the committee and the committee staff, and we believe there's a path to fix these issues. Our immediate concerns are issues. Remember, we are a Homeland Security network provider. Critical that that information remain secure, proprietary information on our competitive businesses. The final issue I want to raise with the committee, and that is that in our industry, it is not clear that the Commission staff has the knowledge or the experience to understand what is proprietary, what is competitive, and what could actually cause economic or financial damage to a company if it were released prematurely. So it's very important we work together to find a solution. And I think the emphasis here is to work together with both the author and with the committee. There's a pony here somewhere. We'd like to work with you to find it. And so thank you for the opportunity to testify. Thanks.
And Mr. Chair, member Cindy Howe of Southern California Edison, and I will just say that I echo the comments that have already been expressed. Our concerns with this bill and this issue are exactly the same as those voiced by the telecommunications industry, and we look forward to working with the committee and the author to find the path forward. Thank you.
Thank you.
Mr. Chair and members, CTIA, Steve Carlson for CTIA, we echo the comments of our wireless colleagues. It's sort of, in a way, kind of an alternative universe. One of the things that we really, it's certainly noteworthy in the PUC reform package that was put out, is that there's a serious question raised about whether or not the wireless industry or telecommunications industry, and we would submit wireless, should even be part of this whole thing and be involved in this. And we hope as we move forward, those issues are taken into account as we're looking at not only this, but other issues as they go forward. For now, we oppose the bill unless it's amended, but we certainly are willing to and have been working with the senator for the better part of this year and the last couple of years on the issue.
Thank
you. Good afternoon, Mr. Chairman, members. James Jack here on behalf of CalTel. We continue to share the same concerns regarding due process and the fact that that is not clearly articulated at this point in time as it relates to the new ability of staff to make these determinations. However, we do want to thank the committee for the amendments that were proposed, and with Senator Hill's adoption of those amendments, CalTel is removing its opposition to the bill. Thank you.
Thank you.
Susan Libert with T-Mobile, and I also want to compliment the author and his staff for working with us. While we are opposed unless amended, we too look forward to finding a path forward with this author and his staff. Thank you.
Thanks.
Good afternoon, Brenda Coleman here with Sprint. Just wish to align myself with the comments already articulated by our wireless colleagues. Thank you so much.
Thanks.
Yolanda Benson on behalf of CalCom, echoing what has already been said by the telecommunications industry.
Okay, let's go to the panel here. I guess the first question is, there's a lot of big picture concerns, and then there are some very narrow concerns. This chair, for one, believes there's a lot of merits and validity to the point of that a lot of the telecoms have raised. Not trying to divide the opposition, but why not just take out telecom? I mean, from this measure. I mean, particularly because safety is not typically an issue that applies to telecom.
Well, it's not, but we're looking for a path that kind of includes everything that's within the PUC, and that's, I think, the goal. And we've had, there have been a number of examples that I could go through of telecommunication issues where there have been, violations or actions of the telecommunications issue or proceedings. Obviously, we know that there are numerous proceedings, and I think we want to make sure that it is inclusive and not really segment out the PUC in different areas. So I think it's important that they be included. I know it'd be easier, they'd love to not be, but I think at this point, I think we can get to the path that they're talking about where they can be included so that we can be as comprehensive as possible with those regulated entities within the PUC.
Is a path to clarify by statute, though, that what I think of the 5% and the 95%, that the 95% is not something. Because, obviously a request can be just so voluminous, difficult to deal with, and then there's the issue of releasing it, of course, it coming out to the public. And I do understand that when there's a company where, you got 95% of your operations are national in scope, regulated by the federal government, related to the internet, not regulated by the state commission, and that data could possibly come out, just because one state's employee, it just, look, it's food for thought.
No, and I think it is, and I think it's something that we will continue to have in those conversations to see if, and especially if things, and maybe we just need to discuss that a little more to see.
Terrific. Thank you very much. We appreciate it. Questions, comments? Mr. Hadley.
Thank you, Mr. Chair. Just start echoing some thoughts that some other people have made, Mr. Chair. I really applaud your work on PUC reform, and over the last year, I think I've been well aligned with you on virtually all of it, and I hope that will continue to be the case on this bill and on the other work. I'm really concerned about the bill generally. I mean, the opponents have respectfully said they hope there's a pony in here somewhere, and I'm certainly open-minded about that. But the foundation for so much of what the PUC does is this unfettered access to corporate information. It is unprecedented in most other areas of how the government at any level does business with any private actor, and the PUC has the authority to ask for anything, whether it is covered within its regulatory jurisdiction or not. And at least my understanding to date has been that there have not been problems with the unauthorized leak of this kind of information. In order for the PUC to continue to be able to do the job that it does, I think that kind of exchange of information is foundational. It's very important, and to weaken the framework in which that information can be exchanged, I find potentially alarming, and I think that the future that we would go down here is much more confrontational dealing between the PUC and the entities from whom it gets information. So I'm, the language in the committee amendments around if information is not illegal to release under federal or state law, that sounds good the first time I read it, but this is an almost unprecedented relationship between a regulator and a regulated entity, and there's a lot here that wouldn't be prohibited under federal law because nobody else is required to give this kind of information under federal law. So I'm concerned about the direction of this generally, but I do think it's too broad. And at the least, if we were going to proceed on this basis, I think we would have to limit the information on unregulated activities that would be discoverable, if you will, by the PUC. Thank you.
Terrific. Questions? Other questions? Mr. Quirk.
Thank you, Mr. Chair. I'd like to second the comments of the chair about the telecommunications industry, and I think Mr. Hadley brings up something which I don't think you want released. So if you were to put that in the bill, clearly it could probably help the bill move forward. Would that be something you'd be willing to do? Or at least let's...
What specific?
Yeah, Mr. Hadley talked about information which is of competitive importance.
Right.
Now,
of course.
And you specifically talked about public health and safety, public employees and contractor safety, environmental degradation as the three areas where information might be released. I don't think you want to release anything of that type, absolutely. And so having a prohibition for that, I think, would be helpful in the bill.
Well, and I think it is, and I think in the amendments it's identified in there as of a competitive nature, anti-competitive nature would not be able to be released in
yeah, actually, I do see it here.
But that is
well.
That's
what you said is that there's still a penalty if somebody releases that.
Yeah, and we're trying to eliminate the penalty because for some of the aspects of it.
Yeah, no, for a whistleblower, but. What we're pointing out here is that it would probably be useful in terms of bringing the opposition off if you were to add language that this did not apply to release of information of a competitive nature.
We'll make sure that that's clear.
Okay, thank you. With that, I will move the bill.
Thank you.
All right, bill's been moved. Any other questions or comments? Mr. Vice Chair.
No, I'll defer. I have a real easy one. In the testimony by AT&T, you mentioned Homeland Security. The amendments here talk about certain information not being released as federally restricted. Is that addressing your concern on Homeland Security, or is there something else deeper that we need to be aware of?
I don't think that. I think the fact that the Commission has the ability to ask for anything and everything, even if there's not a proceeding open, and the fact that the bill in its current structure may allow for information to be released at the staff level and has been questioned about whether there's a appropriate notification and due process. It's not clear to me that the staff would always appreciate the sensitive nature of the information, whether it's Homeland Security information, or it could also just be basic public safety information. A perfect example, for example, is recently there was an incident where an automobile hit a box, a telecommunications box. That information is all reported, all the detail, who was impacted, to the Public Utilities Commission. What was important and why we shouldn't have released that information to the public, and we were successful in intercepting the Commission staff so that they would not release that, is that that facility happened to serve the entire police department of that particular locality. You don't want that kind of information in the public domain for those who may have ill intent in mind. So those are the simple little things that on a day-to-day basis that need to be protected. I think the author of the bill understands that. We just need to get the wording down so that we're assured that that protection is there. But if it's something that small or something as large as Homeland Security, these networks are vital to public safety and Homeland Security. So I hope that sort of answered the question.
And if I could respond, Mr. Chair, to some of
Of course.
There's a list. This is a list of all of the statutes that protect confidentiality of customer information. These are the telecoms and every customer of the or participant in the PUC. And there's a list of statutes that protect critical infrastructure information, Code of Federal Regulations, titles, that goes on and on. So there's quite a bit of information that would be used to protect that information when it comes to the PUC and identified as such. Assuming that in that incident that Mr. Devine mentioned, that if AT&T did identify that as critical infrastructure when it was damaged and hurt, so I think it all goes hand in hand.
Well, that was my concern because, as you know, in the world we're in right now, what may seem as mundane information could actually be critical to some terrorist attack. If you know what critical nodes to take out, and if you had a desire to do something like we saw yesterday in Turkey, you could essentially shut off an area for communications. Then the first thing you do in a military operation is to shut off the ability to communicate before you move in. And so that's why this information is really critical, needs not be released. And I don't see anything like that in there. I'll look for your documents. But in a world that we're in today, that needs to be really secure. You don't want that out in the public realm.
Very true.
Mr. Vice Chair, and then we're going to wrap this one up. Thank you.
Take the cue. Really quickly, I've got a real problem with the due process issue here, and frankly, removing a penalty if it's released. It seems to me, my goodness, what we're doing is we're giving bureaucrats within the PUC enormous power to release, if they so choose, without a real checks and balance. And I think that if you got to deal with the due process question and whether or not those who are going to be under the scrutiny of the PUC have protections to be able to make a claim for the privacy and the proprietary information and all of that. And I think to offload that to a staff is a real dangerous thing. I've had 30 years experience in broadcasting being a regulated licensee, and no one at the Federal Communications Commission could go on the kind of fishing expedition with respect to my proprietary information and my licensing process and my oversight. That's why we have due process, and that's why it's important, I think, that we have commissions look at it and have a due process. If you have a problem with the outcomes of the review and the commission, fix the PUC. Don't give the bureaucrats within the PUC the kind of power I think we're giving them here.
So let's. I see no other questions or comments from the committee. Would you like to close briefly?
Well, I would, Mr. Chair, and thank you. And I could respond just one issue on the misdemeanor characterization or the aspect of having making it a crime for someone that may release some information. One, the bill does clearly define what can be released, what shouldn't be released, and what and there still is the criminal aspect of it. But utilities releasing confidential information and with frightening regularity. No one goes to jail for that. 2014, Verizon paid the FCC $7.4 million to settle allegations that it improperly used customers' information to market new services to them. 2015, Comcast settled with the PUC $33 million for publishing the names, phone numbers, and addresses of 75,000 customers who had paid to keep that information private. 2015, AT&T paid $25 million to settle with an FCC for a data breach in which employees at overseas call centers sold $280,000. I'm going on. PG&E right now, there are criminal proceedings against PG&E for the actions in San Bruno. Criminal proceedings. Not one executive, not one of those individuals who made the decision to divert hundreds of millions of dollars from safety, from maintenance and operations will go to jail because of that, and they should. My point is, we're going to pick on the employees of the Public Utilities Commission for doing their job, and they're the only ones that are going to go to jail? That doesn't seem fair. Thank you, Mr. Chair. I respectfully ask for an aye vote.
Thank you very much. So it's our understanding that we're going to continue to work together to find that pony or the unicorn.
We'll find it. I guarantee you we will.
Bill's been moved by Quirk, seconded by Hernandez. And Madam Secretary, please call the roll.
The motion is due pass as amended in the committee analysis and re-refer to the Appropriations Committee.
Yeah, moved with the committee amendments. Yes.
Gatto?
Aye.
Gatto, aye. Patterson?
No.
Patterson, no. Burke? Aye. Burke, aye. Chavez?
No.
Chavez, no. Daly? Eggman? Christina Garcia? Aye. Christina Garcia, aye. Eduardo Garcia? Hadley?
No.
Hadley, no. Hernandez?
Aye.
Hernandez, aye. Obernolte?
No.
Obernolte, no. Quirk?
Aye.
Quirk, aye. Santiago? Ting? Williams?
Okay, we're going to place that on call, and we'll return at a later date. Okay, Mr. Hill, you have one more bill before us, and that is 1049.